Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. If you've been watching this channel, you've probably seen some of my coverage about the lawsuit between G-WACS Armory and KE Arms, Sinistro Rifleman, Brownells, and so forth. Now, G-WACS Armory has just put out a statement on their webpage. And you guys know it's Canadian Thanksgiving, right? It's not Christmas. You didn't have to get me a present, but I'll take it. So we're going to go through this statement and we're going to do some receipt checking because there's a few things in here, well, lots of things in here that really deserve to have some receipts checked. So we're going to go through this and then we're going to have a look at what the actual documents that are available have to say about this because they don't quite match up. Let's have a look at this statement. All right. It has come to our attention that individuals involved with KE Arms and InRange TV are spreading misinformation about pending litigation between G-WACS Armory, KEA, Russell Fagan, and others. Armory will try this case in a court of law and not in the court of public opinion. Therefore, we will not be making additional statements at this time. And this is normally where you'd stop if that was going to be your position. But that's not. However, due to the threats we have received as a result of the videos and articles published about Armory and the litigation, we will state as follows. Now, they did say in one of their documents, they said that they got a threatening phone call. Well, I mean, this happens when people know your name. I've gotten 2 death threats this month, so, I mean, it's just a thing that happens. So they go on and say, we will state as follows. 1. Armory is a licensed firearms manufacturer that sells firearms and has sold thousands of CAV-15 Mark IIs. 2. Armory and the many veterans in our company are ardent supporters of the Second Amendment. 3. Prior to Armory filing a suit against KEA in Oklahoma, KEA sued Armory in Arizona. The federal court in Arizona dismissed all but one of KEA's claims and transferred the case to Oklahoma. The fact KEA sued Armory first is left out of the articles and videos attempting to claim Armory filed this case to somehow diminish gun rights, which is absolutely false. Contrary to the claims in Carl Casarda's video, Armory is neither claiming that the A1 length of pull nor the use of a trapdoor buttstock is its intellectual property. 5. When Armory purchased the CAV-15 product line and all intellectual property, IP, related thereto from Russell Fagan's company in 2011, Fagan represented to us that his company exclusively owned the CAV-15 tooling and design, and that the IP package included his know-how and all of the information he had on actually producing CAV-15 receivers. And 6. Armory had designed new features for the next generations of the CAV-15 and disclosed those features, amongst other things, to KEA, Fagan, and Brownells pursuant to non-disclosure agreements, and NDAs. Those features are included in the products being sold by KEA. They go on to say, when Armory discovered KEA and Fagan were producing products containing elements that existed only in the CAD design files Armory purchased from Fagan's company in 2011, as well as features disclosed under NDAs, it sent a cease and desist demand to KEA and Brownells, who was marketing KEA's products and was also subject to an NDA. 6 days later, KEA sued Armory in Arizona. This case is about protecting Armory's rights to its trade secrets and IP in order to create and sell new AR-15 products. This case has nothing to do with gun control, as others have ridiculously claimed. Armory may make additional statements at the conclusion of this litigation, but until then, we will proceed with the litigation in an honest, professional, and ethical manner. All right, so that's their statement sort of in its entirety. Now, let's go back and check some receipts on this because, yeah, I'm going to have some opinions. I'm going to have some thoughts, having been reviewing all these documents. So, let's begin. Point 1. Armory is a licensed firearm manufacturer that sells firearms and has sold thousands of CAV-15 Mark IIs. Now, I don't think anyone's disputing that they are a licensed firearm manufacturer or that they've sold thousands of CAV-15 Mark IIs. The main issue is, have they always been a licensed firearm manufacturer during the time when they were manufacturing and selling firearms? That's the real interesting question, and that's the one that's at issue in the litigation. So this phrasing is kind of skirting the issue. So let's have a look at that question. And we're going to go back and have a look at the deposition of Judd Gudgel for this to see what he has to say. So question, did Armory possess an active FFL at the time they were doing this contract? Answer, yes. Question, did it during the entire duration of this contract retain an active FFL? Answer, there was a period where we had an untimely renewal based off of COVID. Untimely renewal. Okay. Question, you keep saying untimely renewal, but you would agree with me that it wasn't a renewal of the prior FFL number. It actually had to issue you a new FFL number, correct? Answer, based off of the way the ATF works, correct. They actually, and to clarify that, they actually cashed our check timely, they just didn't get it through the whole process. So that doesn't sound like a renewal, it sounds like they had to get a new FFL. Question, did ATF do you guys a favor and backdate that new FFL to the date so that there would be no lapse? Answer, no, they can't. Question, they can't? Legally they can't, right? Right. Question, so there was a gap in time when Armory did not have an FFL, correct? Correct. And then I'm going to skip over a little bit here, but they just establish, when this occurred. It says, answer, so yeah, like I said, I think it was April of 2020. Did you say that? Question, but sometime during 2020, there was a lapse within the FFL where you then had to get your new FFL number issued so that you could continue moving forward as a federal firearms licensee. Answer, yes. So, and then question, was there any time during the period of the contract that you're suing for under breach of contract that GWACS was not current with the Secretary of State in Oklahoma? Answer, I've seen that in here, yes. But it became reinstated at some point in time? Yes, in Oklahoma, at any time that you catch up, it's reinstated as if it never occurred. Question, okay, and is it part of? That's my understanding. So I'm going to skip forward a little bit here just to get to the key dates. Remember, 2020 is our sort of critical period here, and we'll just sort of skip forward a little bit just to get to that. So question, were there any firearms that were sold in 2020? Answer, I would think so, but I don't know. Question, okay. Were there any firearms that were sold during the time period in which the FFL had lapsed? And then immediately their counsel gets up and is going, okay, we're going way beyond the scope of this, asking about their sales of firearms now and whether it was under an FFL lapse or not. I mean, I think we're going way beyond the scope of this notice. Yeah, this lawyer's actually doing a really good job here preventing that question from being answered, because I feel like that's an important question that could get them into a lot of trouble. But that kind of suggests that the answer might be yes. That's kind of my hunch on that one, but I don't know for certain. But the statement that they put out here very carefully doesn't say, hey, we continually have been a licensed firearm manufacturer, and this is the open question that's been left out there. So point one seems to be very carefully phrased to avoid a pretty critical issue here. This could be a big deal. Point 2. Armory and the many veterans in our company are ardent supporters of the Second Amendment. Well, let's go back to Mr. Gudgell's deposition, because he's got some interesting things to say about this too. Now remember how there's two companies, there's G-WACS Defense and there's G-WACS Armory? Well, let's have a little look at this. So question, does Defense and Armory share assets? Not that, no. Do they utilize the same employees? Yes. Okay, so does Armory have any employees of its own? And the answer is no. That's what I stated earlier. It has employees of its own when we're in the manufacturing process. Now, I'm just going to note here that they haven't been in the manufacturing process for many years. So, other than that, it just contracts employees as needed out of Defense? Correct. And does it pay Defense for use of those employees? No, I think it goes back to what the statements was in his deposition, was compensated for being able to buy guns. So, Armory doesn't appear to actually have any employees, which makes it interesting about how they've got these many veterans who are Second Amendment supporters. If you don't have employees, that's kind of an interesting statement to make. And remember, this distinction between Armory and Defense is kind of an important thing, because there's a reason why Defense exists, and I covered it in a previous video, but we're going to go over it again, because I'm not going to make you go back and watch that other video again. Let's just have the information. So, question. When you say that you formed Armory for the purposes of providing services to defense initially, right? And you say it was to be able to hold the FFL, was there a reason that you didn't have defense just simply get its own FFL? Defense has various owners, defense has various investors and other owners. It just wasn't something that looked like it was anything that any of those guys wanted to do. And we have a lot of people that have objections to guns themselves, which is why they like gunshot detection, which is what GWACS defense is. So when they tell us, hey, listen, Armory is an ardent supporter of the Second Amendment, well, Armory is a subdivision of defense that's basically created for the entire purpose, it seems, of keeping the anti-gun people in defense from having to, sully their names with an FFL. So when you say that Armory is an ardent supporter of the Second Amendment, well, you've noted it's got no employees and that its entire purpose is so that the anti-gun people don't have to be sort of contaminated by it. Well, I guess no kidding that it's a supporter of the Second Amendment. I don't even understand how. Like, this makes no sense. This to me seems like some very careful phrasing. They say Armory, but they don't say GWACS in general. They certainly don't say GWACS defense. So, yeah, I'm going to put a Pinocchio on this one. Point 3. Prior to Armory filing suit against KA in Oklahoma, KA sued Armory in Arizona. The federal court in Arizona dismissed all but one of KA's claims and transferred the case to Oklahoma. The fact KA sued Armory first is left out of the articles and videos attempting to claim Armory filed this case to somehow diminish gun rights, which is absolutely false. This one's going to be easy to bring the receipts on because I don't actually have to go anywhere other than the statement itself, which says, when Armory discovered KA and Fagan were producing products containing elements that existed only in the CAD design files Armory purchased from Fagan's company in 2011, as well as features disclosed under NDAs, it sent a cease and desist demand to KA and Brownells, who was marketing KA's products and was also subject to an NDA. 6 days later, KA sued Armory in Arizona. So this provides an entire explanation for what happens here, because when you send a cease and desist to somebody, there's a very limited number of things that happen. Option 1 is they cease and desist, but that typically doesn't happen when people don't think they've done anything wrong. Option number 2 is that they don't cease and desist and you sue them. Option number 3 is they don't cease and desist and you don't sue them because you were bluffing, but that's not really something people like to bank on either. Or option number 4, they don't cease and desist and instead they sue you for a court ruling to say, no, we're in the clear. This happens all the time. This is a kind of an expected result of sending a cease and desist, especially when when two people are doing business and you send a cease and desist saying, you guys got to stop doing business. Yeah, that tends to get you a lawsuit because people say, listen, we intend to keep doing business. So yeah, they're trying to make it sound like they didn't start this one. They started this one. This is, again, some weasel wording here. Anyway, yeah, I'm getting a little annoyed. Point 4. Contrary to the claims in Carl Casarda's video, Armory is neither claiming that the A1 length of pull nor the use of a trapdoor buttstock is its intellectual property. You know what? I'm going to partially give them this one because I've read through the deposition transcript and I still don't know what they think their intellectual property is here. They've got some really interesting theories, but I don't know that they really get down to specifics. They get down to some real vague stuff, like that polymer is cheaper than aluminum, which is known to literally everybody in the firearm community, but they're claiming that that's intellectual property somehow. And then we've got this little gem. So, question. Okay, so we've got Armory and KA, right? Everything. So your position is that everything Russell had in his brain relative to the CAV-15 became your exclusive property. Correct. And everything that Russell had in his brain relative to the development of polymer, was that your property as well? as it relates to the CAV-15. So that's a really interesting notion that they are buying the contents of his brain. I think that that's one that's going to be a real hard sell to a court, but okay. Let's just also have a look at the sales contract and just see what it says and see if it backs that up. So this is the assets that they purchased. So one Van Don 300 Press HT series model. I don't know what that is, but it's an object. So they buy this specific object. 2, Conair SC30 plastic dryer with hopper, another specific object. 3, Branson 90 series linear vibration welder model, and again, a specific physical object. 4, takedown pin sets, 1,500 plus, so lots of objects. 5, serial number tags, 1,000 plus, again, lots of physical objects. 6, CAD drawings, design prints to the molds, including any and all intellectual property related thereto. Okay, so now we've got a claim to be buying some intellectual property, but it's real unspecific as to what, which is not a good thing when you're buying intellectual property, because typically intellectual property is important, and so you want to specify things like, we get access to this specific patent, and we have access to these specific copyrights and these specific trademarks. Any and all is real vague, and notably, you can't just manufacture intellectual property out of thin air. You know, if there is a copyright there, you can acquire the copyright, but just because you buy any and all intellectual property doesn't, for instance, create a patent or create a trademark or create any of these things. And certainly they're not asserting that they have a patent or that they have a trademark or any of that. So that's a bit of a problem. And here's the other thing, is that unless there's some clause of exclusivity, like a non-compete agreement, typically this isn't exclusive. If you are buying a copy of the CAD drawings and also the copyright to the CAD drawings, that doesn't necessarily mean that there aren't more copies out there. Copyright doesn't let you, reach out and destroy other people's copies of things. So this doesn't necessarily say that no one else could have a copy of the CAD drawings. That's a bit of a problem. And takedown pin specifications. Okay, that's a specific, thing. And then miscellaneous tools and equipment to manufacture, market, and sell the lowers. Quite frankly, I don't practice in this area. I don't do these kinds of business transactions. But I can see the problem with this one. This is like law school problems. Yeah. So I have some thoughts on that. And yeah, when they say that they're neither claiming the A1 length of pull nor the use of a trapdoor buttstock, I don't actually know what they think they own here. It's really, really vague and really super weird. But, I mean, we can go and have a little look at, at some stuff here, because they're also a little contradicted, just a wee bit. So we'll just pull that up. So question, yeah. And does it talk also about a lightweight trapdoor butt plate? Do you see that, as you can see that on the paragraph? Yes, okay. Do you claim any proprietary rights to the concept of a sling swivel or any butt plate with respect to the CAV-15? On the design that we proffered to them to build, yes. So it does appear that they claim some rights to the concept of at least a trapdoor buttstock. I really don't know what they think they own, even after reading all of their documents, because the claims as to what they think they own are either so vague as to be like, we just own everything, or they're just ridiculous. So I guess I'll give them partial points. I don't even know how to rank this one. Point 5. When Armory purchased the CAV-15 product line and all intellectual property, IP, related thereto from Russell Fagan's company in 2011, Fagan represented to us that his company exclusively owned the CAV15 tooling and design, and that the IP package included his know-how and all of the information he had on actually producing CAV15 receivers. So that sounds good. Let's see if the purchase agreement actually backs that up. So you already know where this is going, right? So representations and warranties of seller. And of course, the seller here is Russell Fagan's company. Seller represents and warrants to purchaser that 1. Corporate existence and qualification. So this basically just says that Sinistral Shooting Technologies exists as a company and is able to do business, which is an important thing if you're trying to do business with that company by buying stuff. So that's what this first representation is. The next is title to assets. This is the important one. Seller has good title to the assets of record and beneficially, free and clear of all liens, claims, encumbrances, and restrictions of every kind. Now, good title to the assets isn't the same thing necessarily as exclusive anything. So, okay. Authority. This agreement is a valid and legally binding obligation of the seller and is enforceable against the seller in accordance with its terms. Fair enough. Like, this contract is a contract. I'd hope so. No conflicts. So this basically just says that there will not be any conflict with any other agreement. So you're not selling this to two people at the same time. You're not selling this in violation of any mortgage. You're not selling this in violation of any court order, because that's important. And, you're not selling this in violation of any laws. Okay. And survival. All representations and warranties of the seller shall be deemed made as of the date of this agreement, and again as of the closing date, and shall survive the closing for 5 years. Now, note that 5 years ended a while ago, so that whole thing about how long it survives, there's a termination date on that, and it's done, and has been for a long time. Now, there's another provision here that we do need to look at that is important. And that is this one here, integrated agreement. And this is a provision that basically limits the scope of the contract and basically is designed to facilitate, it's designed to prevent litigation by ensuring that there's no sort of confusion. And it says, this instrument contains and constitutes the entire agreement between the parties herein, and supersedes all prior agreements and understandings between the parties hereto relating to the subject matter hereof. There are no agreements, understandings, restrictions, warranties, or representations among the parties relating to the subject matter hereof, other than those set forth herein. All exhibits and all schedules attached hereto or delivered pursuant hereto are hereby incorporated herein and made a part of this agreement. This instrument is not intended to have any legal effect whatsoever, or to be a legally binding agreement or any evidence thereof, until it has been signed by both parties hereto. So there's a few things here. First, it says we don't have a contract until we actually sign it, which makes sense. But the more important aspect is that it says, listen, it doesn't matter what conversations we had. It doesn't matter what discussions we had. All of that is eliminated. The only agreement is that what you find here. So even if, for instance, Russ Fagan made promises, he swore on his heart and, wrote it down in blood in some other document, doesn't count. This is the entirety of the agreement. So anything not in this agreement doesn't exist. It's made up or doesn't matter. So yeah, if they're trying to rely on some claim of a promise outside of this agreement, that's not going to go well for them because they specifically said that wasn't going to be a thing. Now, again, we can just review the assets. We have a thing, a thing, a thing, many things, and CAD drawings, design prints to the molds, including any and all intellectual property, IP related thereto. So you've got a warrant or a warranty relating to any and all intellectual property related thereto. Good luck enforcing that. Like, I don't know what that means. The court doesn't know what that means. Nobody knows what that means. So, I mean, this only tells us relating to stuff that exists. And when we see that they're saying that he was saying that he was going to have his know-how. Know-how isn't IP. Know-how is something else. It's not part of intellectual property in this unless it's something like a trade secret, which they don't have. Or if it's something, yeah. Know-how doesn't appear in that document. So, yeah, I don't know what's going on with this statement, but it's clear that these guys seem to think that something's going on that doesn't appear to be going on. Point 6. Armory had designed new features for the next generations of the CAV-15 and disclosed those features, among other things, to KEA, Fagan, and Brownells pursuant to non-disclosure agreements, NDAs. Those features are included in the products being sold by KEA. All right, so let's have a look at what he says those features are, because that's kind of important. So back to the transcript. Question: what specific proprietary information are you alleging was used? Well, there's multiple things. I need a list of all of them. IP, I'll go through what I can recall. I love it when stammering is recorded in a transcript. Again, I'm not an attorney, so that's something you guys get to find out and the jury gets to decide. You'd think that when you're going into a deposition, you'd be prepared to answer this specific question. Like, this is kind of a critical question to the litigation. This is not something out of left field. This is something that should have been prepared for. When you look at, we disclosed to them using the quick attach on the CAV-15, the larger trigger well on the CAV-15, and then, of course, to me, when you say the IP encompasses lots of things. Okay, I want to be very clear because we've got to break this down because I need to know exactly what you have. So what is the proprietary information that you believe was either used, disclosed, or exploited? The CAV-15. I mean, I want to laugh because it's so silly, but I mean, so a lot of my viewers aren't necessarily gun owners, but when you see, a quick attach or a larger trigger well, this is the equivalent of saying, listen, we disclosed to them the top secret information that the next generation of our cars might have a model that has leather seats. Yeah, I mean, lots of guns play with the size of the trigger well. Lots of guns use quick attaches. This is not super secretive. Nobody could have figured this out. I was kind of expecting we'd see something, like some unique feature that's never been done before. Not like, hey, our car's going to have tires. Okay. So, yeah, I mean, I guess breaking all of this down, there's a lot of points where I'm thinking, okay, this looks like a very careful sort of deception by omission kind of statement where they say, oh, look, Armory and its employees really support the Second Amendment, but Armory doesn't actually have any employees and exists in order to shield the anti-gun people from needing to be included in the FFL because that'd be awkward. So, that kind of very careful phrasing, along with stuff that makes me think that they're just kind of like, I don't know how I got here and I don't know what's going on and can someone explain this to me? So it's really hard to figure this out. Yeah, this is kind of frustrating. I know I said that this is kind of a gift to me, and I do like going through this kind of stuff, but I'm just wondering, like, what is with this statement? Do they think people are gonna just accept this uncritically? Because I'm certainly not. When I see something like that, I want to go check the receipts, and hopefully you guys agree that I brought the receipts on this one, and yeah, um, I guess my expression here kind of speaks volumes. So, thank you for watching. I hope you've enjoyed this review of that statement. Please like this video, share it with your friends, subscribe to see more content. Please leave a comment if you've got questions, if you've got things to say. It really does help with the algorithm, the great secret YouTube algorithm. And I also want to thank my Patreon supporters. There's a link if you want to become one of them in the description below. I'm also going to link the actual statement itself so that you can check that out and see that I'm not making stuff up about what's in there. So at the $50 level, Canada's National Firearms Association, the CCFR, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited. And at the $20 level, Mark, Jane Babe and Luxor, Haywire, Dale Nesbitt, Cameron Johnson, Andrew Elsich, and Vicky. Thank you as well to my supporters at the $10 level who will be in the crawl immediately following. Thank you for watching. I hope this has armed you with knowledge, and I hope you enjoyed that one as much as I did. See you next time.